All right, the Senate conferees will come to order. And we're now open to, we'll stick with Title I first. Let's just do it title by title so we have some order to this. And let me entertain any additional amendments to Title I. Title is open for Title I.
You want us to just, I'll let the senior senator from Alabama go first.
Good judgment there.
There you go. I've learned a lot during this conference.
Is he deferring you?
You're up.
I'll be glad. Thank you. Mr. Chairman, I have an amendment dealing with the council approval of capital requirements. I think most of you will have if you don't have the amendment, and I'd like to speak on it for just a few minutes.
Senator Shelby's recognized.
Mr. Chairman, this amendment will help ensure that our banking system has strong capital requirements. The recent financial crisis, as we all know, revealed that our financial institutions were undercapitalized and that existing capital requirements were inadequate. One reason why we have inadequate capital requirements is that the complexity surrounding capital determinations makes it very difficult for Congress and the public to determine if a particular capital rule is sound itself. As a result, there's been little effective oversight of capital requirements by our regulators. To address this problem, Mr. Chairman, this amendment will require the federal banking agencies to prepare a report describing any proposed rules on capital requirements. The report will show how the rule would impact the amount of capital banks hold. This would make it much easier to determine whether a particular rule would increase or decrease the amount of capital held by our financial institutions. Mr. Chairman, no longer will Congress and the public have to blindly trust our regulators about how capital requirements will impact our financial system. This amendment before us will ensure that there is clear and understandable data on the impact of new capital requirements. In addition, this amendment will require the Financial Stability Oversight Council to approve any changes in capital requirements. And since the Council is responsible for monitoring financial stability, I believe it's appropriate that it has the final say on capital requirements. Senator Dodd has long advocated for a dynamic council to monitor our entire financial system. This amendment will ensure that the council actually has teeth. Furthermore, requiring the council to approve changes to capital requirements will help address the problem of regulatory capture. Far too often, financial regulators become captured by the financial institutions that they regulate. And as a result, the capital rules they have developed have not been as robust as they need to be. Requiring the council to approve capital requirements promulgated by federal banking regulators will help ensure that capital requirements are not watered down. Requiring the council to approve capital requirements will also improve accountability for financial regulation. The amendment will require the Treasury Secretary to vote to approve any rule on capital requirements before such rule can become effective. And as a result, if new capital requirements undermine the stability of our financial system, it will be clear which administration is to blame. This will make it easier for the voting public to hold accountable those responsible. Future administrations will know they need to take financial regulations seriously because they will be on the hook. Accordingly, this amendment is a common-sense way to strengthen capital requirements without micromanaging our regulators on this very complex subject. I'd urge my colleagues to support the amendment.
Well, first, I thank my colleague. Let me just briefly, I'll ask anyone else wants to comment on this. First of all, I don't know of anyone on our committee who has been more consistently outspoken about capital requirements than my friend and colleague from Alabama. I don't recall a hearing we've had in my stewardship as chairman over the last 38 or 39 months where Senator Shelby didn't raise the importance of capital standards. And so let me begin by commending him for his consistent support for this issue and his consistent efforts to point out the failure in the past of not requiring adequate capital standards is one of the contributing factors to the situation we're in. But I reluctantly have to disagree with this amendment. I think it's very cumbersome, first of all, and it requires a lot more reporting requirements and so forth, at just at a time when we're already going to be asking a lot more to be done of the various agencies and departments. But also what it does, if you go to the third paragraph, in effect, this gives the Treasury Secretary veto power, because in the absence of the Secretary of the Treasury voting in the majority for it, regardless of what anyone else has to say, so a political appointee gets to basically determine capital standards. And while that may be great for trying to identify which administration at what time has been more strident on this issue or not, I think to give one individual like this the power to determine all of these issues is far more than I think we want to empower a political appointee to be able to control. So the banking agencies would have to go through a very cumbersome process, and also submit incredibly detailed reports. We already have the Collins Amendment, which seeks minimum capital standards to ensure financial stability. And I commend my colleague from Maine who we accepted that amendment of hers during the Senate debate. It's a very important issue, and I don't want anybody's suggestion of not supporting this amendment in any way minimize the importance of the effort that Senator Shelby has made to insist upon this, and it'll be one of the important factors to monitor. But I would be very hesitant to want to give the Secretary of the Treasury the veto power over all other regulatory bodies, in a sense, when it comes to capital standards. And for those reasons, would urge a rejection of the amendment.
Can we get a vote?
Anyone else want to be heard on this? If not, do you want to vote?
Roll call.
I'd ask the clerk to call a roll.
Mr. Chairman.
No?
Mr. Johnson.
No.
Mr. Reed. No. Mr. Schumer.
No by proxy?
Mr. Schumer, no by proxy. Ms. Lincoln. No. Mr. Leahy.
No by proxy?
Mr. Harkin.
No by proxy?
Mr. Shelby.
Aye.
Mr. Crapo.
Aye.
Mr. Corker.
Aye.
Mr. Gregg.
Aye by proxy.
And Mr. Chambliss.
Aye by proxy.
Clerk will report.
5 ayes and 7 nays. The measure is not passed.
I thank the clerk. Are there additional amendments to Title I?
Yes, sir. I'm going to,
Senator Corker.
I have several, but I'm going to try to be very brief with them, and I thank you for the
Why don't you comment on all of them, and then we'll, and I believe most of them we're going to accept. So.
Yeah, that'd be good. Section 165 of the conference text allows the Board of Governors to impose heightened prudential standards and reporting disclosure requirements on non-bank financial companies. And obviously, in some of these situations, the subsidiaries are the largest piece of it, and they're actually regulated by some other prudential regulator. And I would just ask, all my amendment does is it says that when the Fed sets those capital requirements, they have to consult with those people that actually do the prudential regulation. And I think it's a good government amendment. I hope you'll just take it, and we won't even have to vote on it.
Great. Unless there's further debate or discussion, I think it's a good amendment. I commend my colleague for it. Amendment, unless otherwise objected to, will be accepted. Additional amendments?
Okay. Another amendment, amendment number 2 is, Mr. Chairman, I think you're aware of all the effect that accounting has had on our banking system throughout this time. I have not been one to want to water down accounting standards, but I do think it's very important for us to make sure that we have somebody monitoring, and I think the Financial Stability Oversight Council should monitor not only what's happening here accounting standard-wise, but also what's happening internationally. And while your language in the bill, the base bill, says advise, I think they should monitor and actually actively talk with us about what's going on. We may in fact want to weigh in with some of the financial, with some of the accounting boards. So this would just give them the opportunity to do that. I hope, again, you'll just take it.
I agree with my colleague's analysis. I think monitoring that would be very worthwhile. Is there any further debate on the Corker Amendment number 2? If not, all those in favor say aye. Excuse me. That's already been accepted, the second one. This is one, is a monitoring of accounting. My colleague have a chance? All those in favor of Corker Amendment number 2 will say aye. Aye. Those opposed, nay. Ayes appear to have it. The ayes have it. Corker Amendment's adopted.
Okay, now there's amendment number 1. This one really has to do with what we've been discussing with Collins. There are other types of hybrid instruments that, other than just preferred trust, and this would put in place an 18-month study and in no way changes the Collins amendment, and I hope we are able to change that over time. But what it does do is put in place a GAO study involving the OCC and others to do a study on how these various hybrid instruments affect the banking system. Again, I hope you'll just take it and we can move on.
I think it's a good amendment. All those in favor of the Corker Amendment will say aye. Those opposed, nay. The ayes appear to have it. The ayes have it, and the Corker Amendment's adopted.
And I have one last amendment, and I'll stop. This one you may not take.
You're on a roll now.
Mr. Chairman, you and I both sat through the multiple discussions regarding Title II and resolution, and I know that resolution has been one of the most contentious issues. We spent a lot of time discussing it. We've talked about pre-funding, post-funding. I think one of the issues that we never had the opportunity to really look at was changing the bankruptcy code. I know you and I talked to Senator Leahy. We talked to Senator Sessions. There are multi-jurisdictional issues relating to this, but the fact is we never did the work, and I know that's not our committee's jurisdiction to do. We never did the work to really look at bankruptcy. We also are developing a resolution mechanism almost in a vacuum. In other words, we're looking at the way things were 2 years ago, when in fact this bill is going to change tremendously the way things are. I mean, we're going to have a clearing mechanism for derivatives. The counterparty relationships are going to be very, very different. And so what this amendment would do is direct the Federal Reserve and the Administrative Office of the U.S. Bankruptcy Court to do a study on what we would need to do to bankruptcy law to change it to make it more effective for complex entities like this to actually go through bankruptcy. I think what we've done by not doing the work on the judiciary side is we've almost confirmed that in every case we're going to use this resolution mechanism. I don't think that was our intent.
Let me inquire of my colleagues. Again, I have no objection at all. Very good point, by the way. This is when as I listened to our House colleagues, you and I were sitting here today, talk about this, and we have the sort of rules not to jump into their discussion. But clearly, and again, Senator Corker is correct about this. We all understand this. The bankruptcy proceedings, what we're going to need to have, are going to have to be different. And there was just no way for us in the midst of this whole debate and everything else that's going on to get the Judiciary Committee to rewrite the bankruptcy code regarding this. They made some changes for us to accommodate certain parts of our bill. And the reason being, quite candidly, is because we know the present bankruptcy structure, where you end up with highly complex entities where there are residual effects of going into bankruptcy, can be complicated. And so there clearly needs to be done. And so I agree with them on that. And certainly the studies, and we have some studies already in the bill, but I don't have an objection to having heightened or whatever we want to focus on that. I would be concerned, and I'm under the, just correct me if I'm wrong, I'd be reluctant to want to sunset everything we've done. I realize that could be a motivating factor, but I can't predict what happens down the road here, and all of a sudden, we're without any mechanism in place. People can hold things up. We know how things can happen in the Senate, depending on what's going on there. And all of the work we've done in Title II, despite this flaw, which you're absolutely correct to identify, I'd hate to want to absolutely put aside all that we've accomplished in this area because we failed to meet some date on a bankruptcy. So I agree with you, it needs to be done. And I agree, a study that would allow us to be able to determine how best to do that, if that's necessary, I don't have any problem with that whatsoever. And so I'm not clear. Are we dropping the
Okay.
sunset?
So
part of this?
here's what look. I know the outcome of the sunset, and I'm not going to ask for a vote on that because I know what the outcome's going to be. But I do believe that the only way to make us act is to ask for the resolution title that we now have in place to be sunset in 3 years. This study would be completed in a year. Give plenty of time for activities to take place through the Judiciary Committee and us actually pass something that may be far more workable. I know, I mean, we can go ahead and have a 7-5 vote now if you wish, but I do think that the study that we have in the bill is not expansive enough to really do the work necessary for us to have the answers necessary to make the changes that I think need to be made in the bankruptcy code. I also think, regardless of whether we were doing this study or not, this resolution title is going to need to be changed because I think the rest of this bill is not being taken into account when we look at resolution. All the other changes that are occurring are going to greatly change just the interconnectedness issues, okay? And I do think that with the tremendous powers that we've given the FDIC, which are huge, and I don't think we have the appropriate judicial checks, I think a sunset of this resolution title actually would be wise and would cause us to do the work necessary to fine-tune it and get it right. Otherwise, we're going to forget about it. It's going to continue to have the flaws that we all know it has today. And we know it has flaws, and we know it's not perfect. So, you know, I won't force a vote on that, but I do hope at least you'll take the study piece and let's really do the work necessary to ensure that we have the information to make those
Let me
changes.
just inquire of my colleague a couple of things. The study part is not in lieu of the other studies in the bill, it's in addition to.
It's in addition to, and where I would just hope the staff, where it's duplicative, would work that out themselves
They can do that.
administratively.
They can do that. And the senator certainly has the right to modify his own amendment, so you'd modify it by striking the sunset provision of the amendment. And then with fine. And again, look, this is, you know, hopefully what we're doing, you're right, there are a lot of changes occurring here. What we're trying to do, of course, with the Financial Services Oversight Commission and so forth, the capital standards requirements, all the other things, is avoiding ever getting to the point. And so you're into that either bankruptcy or resolution situation. And again, the hope is that by doing a good job ahead of time, watching these things, we can avoid that. But I agree with my colleague in that sense, and so I'm more than happy, unless others want to be heard on this matter, to accept the modification, first of all, of the senator from Tennessee, and that would urge the adoption of the study suggestion he's made in this amendment. All those in favor of that would say aye.
Aye.
Those opposed, nay. The ayes appear to have it. The ayes have it, and the amendment is agreed to. Senator Shelby.
Mr. Chairman, I have another amendment dealing with Section 111 of the conference-based text.
Senator is recognized.
This would establish the purpose. This establishes the purpose and duties of the new Financial Stability Oversight Council. These duties include imposing or recommending heightened standards for financial companies that may pose risk to the financial stability of the United States. Similarly, the Council has a duty to make recommendations for heightened standards and safeguards for financial activities or practices that could create or increase significant liquidity, credit, or other problems spreading among bank holding companies, non-bank financial companies, and United States financial markets. In considering the relevant universe of activities and practices and what companies to consider, the Council is to look at things like leverage, the degree of reliance on short-term funding, a number of other things that seem to be reasonable considerations with respect to systemic risk in the Senate-passed version of this legislation. The conference-based tax, however, has added a new consideration. The new consideration is, quoting from the bill, the importance, and I quote, the importance of the company as a source of credit for low-income, minority, or underserved communities, and the impact that the failure of such company would have on the availability of credit in such communities. Mr. Chairman, programs to address credit issues in low-income, minority, and underserved communities currently exist everywhere in our law. For example, the FDIC has established an Alliance for Economic Inclusion which is a broad-based coalition of financial institutions, currently based organizations, and other partners across the country to bring all unbanked and underserved populations into the financial mainstream. This is something we all support. There are similar efforts aimed at low-income, minority, and underserved community needs throughout members of the federal financial institutions examination council, which includes major regulatory bodies. Moreover, an entirely new title was added to the Senate bill that sets up a number of new programs for underserved communities. We could debate whether more resources are sufficient in the existing programs or whether the new title in the Senate bill is necessary. Those are certainly valid issues and consideration to debate. But those issues, I would submit to you, are not pertinent to the title that we're presently considering. Macro-prudential or systemic risk regulation is the subject matter of Title I. Systemic risk regulation is intended to focus on matters that influence the financial stability of our entire financial system and all participants in the system throughout the country. If systemic risk detection and regulation can be done at all, and there's not a consensus among experts that it can, it will involve broad financial and economic considerations devoid of politics. The politically driven, community-based considerations for the Systemic Oversight Council that the base text includes run directly counter to the systemic risk mission that we've set out. As we've tragically seen from our experiences with Fannie Mae and Freddie Mac and with the Fed, to the detriment of millions of now unemployed Americans and trillions of dollars of lost wealth, conflicting objectives and missions are perilous to the stability of our system. I believe distractions for the Systemic Oversight Council from its core mission, indeed its sole mission of financial system stability, would be a mistake. I also believe that the base tax would likely allow community activist groups, such as ACORN, to hijack the Financial Stability Oversight Council as they seek to extract preferential treatment for select groups at the expense of financial institutions, their shareholders, and their depositors. Addressing the financial needs of low-income, minority, and underserved communities deserves our attention. However, mixing these needs with issues concerning stability of the entire U.S. financial system, I believe only creates confusion and distracts the Financial Stability Oversight Council from its core mission, oversight of the financial system as a whole. Mixing community activism with financial stability concerns raises serious questions about the objectives of this legislation. Are we truly interested in mitigating threats to the stability of our financial system, or are we engaging in populist community activism? This is the appropriate title for the former and not for the latter. I urge my colleagues to support this amendment.
Well, let me respectfully disagree with my colleague from Alabama. I forget the exact numbers here, but we literally have millions of our fellow citizens who have never entered a savings loan, a bank, or any other traditional financial institution in our country, out of the mainstream. These are people who get drawn into payday lenders and to other circumstances that, unfortunately, in too many cases, not all, take advantage of the minority community. These were many of the same arguments that were made when we, in fact, in this very room and in these other rooms, worked on the Community Reinvestment Act a few years ago. I recall being up all night. In fact, Senator Schumer and I were apart in different bodies. Senator Sarbanes, I believe, Phil Graham was the chair of the committee in those days. And the same arguments were made about the Community Reinvestment Act and the attempts by our country over the years to make sure that all of our fellow citizens were going to have the access to capital, to mortgages, to loans, to all of the things that make it important for people to achieve the dreams that all Americans have to improve the quality of their lives and that for their families. And the fact that in this bill we're suggesting that an effort ought to be made to see to it that disadvantaged members of our society, that minorities and others, we reach out to those millions who have never been able to access the traditional sources of financing in our country, I think is something all of us ought to be able to embrace. I don't think it detracts at all from obviously achieving financial stability. In fact, I think it enhances that because when every single American, regardless of race and gender, and circumstance has an opportunity to do that, we all are better off. We're a stronger country. We're more secure. There are greater opportunities for all of us. And I don't think this language here in the bill detracts in any way whatsoever. In fact, as I said, quite the opposite. I think it strengthens our efforts as a country to achieve those goals. And so I respectfully would urge the defeat of the amendment. Anyone else want to be heard on this matter? If
Yes,
not,
let me just say one thing. Mr. Chairman, I want to say that I did find it odd that in the systemic risk area, we had a clause that the way I understand these clauses to be, is both in Title I and Title II, actually, that if actions are being taken where an institution may be creating systemic risk, you have to, before you take action, you have to consider if it's going to have an impact on a neighborhood that has minority residents in it. The reason that I spent a lot of time, I created a nonprofit back in the 80s. It's helped about 10,000 folks have decent housing. My point is, I spent a lot of time in the inner city, and what I saw there was, because you didn't have those kinds of robust institutions that serve the community, that could serve the community well in many cases, a lot of people that you were trying to help were actually hurt. If I read this amendment, what he's saying, what I think it means is that we would not, the way the legislation reads, we would allow zombie institutions to continue to operate in these underserved neighborhoods and do exactly the opposite of what it is we ought to be doing. I mean, we would be much better off to let a poorly run institution in one of these neighborhoods fail, so the citizens would have access to a robust institution. And it does sound like to me that what this language is trying to do is protect poorly run organizations that do damage to these neighborhoods because they aren't run properly. And so when the Systemic Risk Council or the Resolution Authority was looking at these, they would say, oh, no. Even though this is a zombie bank, and even though it doesn't have capital, and even though it's poorly run, because it's in a neighborhood of people that are underprivileged and underserved, we're going to let it operate. Mr. Chairman, I have to tell you, to me, that's the opposite of what we ought to be doing.
people can do. I just read the language. Let me just say that we're over-reading the language. In Title I, it says take into account. In Title II, it says how would these affect the communities. So let me read it specifically. So it says, description of the effect that the default of the financial company would have on the economic conditions of the financial stability for low-income, minority, underserved. That's hardly overreaching, it seems to me. I say this, look, we could vote on this stuff, but I mean, to consider that somehow, look, we all know there have been institutions that did a dreadful job in some areas. So a lot of lending institutions do a dreadful job. So do some of these other places we're talking about. But the fact of the matter is, taking into account how this would affect the community, that language doesn't seem to me to be terribly onerous. And the fact that we're striking it all together leaves, it seems, the question of these very fragile communities. I understand the point the Senator is making, but I don't think it's really worthy of striking all of this language, and that somehow the inclusion of it creates a pernicious or overly burdensome set of circumstances. That's my point.
Mr. Chairman?
Yeah.
I just want to associate myself again with Senator Corker. If we, using the words, and you quoted them out of the thing, taken into account. Now, what does that really mean? That means to consider all of these things. To consider something, let's say the bank is broken, that it is insolvent, and say, well, gosh, we're going to bail that bank out. We're going to keep it going. We're going to consider this. We're going to keep it going. This has no place in what we're talking about here. We're talking about a council, and there are other things in the law that protect people, and we all want to protect people, but sometimes you can't protect people from themselves.
Well, we're designating it as being systemically important. Let's remember what we're talking about. And so taking into account with that designation, what are the effects?
Well, the question is it systemically important? It might be socially important, it might be politically important, but is it systemically important? The answer is obviously no.
And taking into consideration whether or not there's an adverse impact in these fragile communities?
But that still has nothing to do with systemic risk.
Well,
Let's vote.
It's social. Let's vote.
All right?
if I could jump in, and I know I understand how this is going to turn out too, but you have a line right above that that talks about, you look at how it affects U.S. households. That's the title above, and then you step down and look at communities, underserved communities in a different way. I might add, we do have a consumer protection title in this bill to deal with the kinds of issues that I think you're concerned about. And Mr. Chairman, I'm saying this as a champion of low-income citizens, that this is the type of politically motivated decision-making that hurts the very low-income citizens you're trying to help. And that's why, by the way, these neighborhoods end up having all kinds of shadow banking mechanisms there that serve them, because these are the kind of decisions that end up being made. And I think it's perverse in the outcome. I understand there are good intentions associated with this kind of thing, but it does end up causing politics. This is about politics.
No, it's not.
It
Look,
is about
there
politics.
are
I'm
11
sorry.
criteria. This is one. Why are we picking on just this one? Why was this one driving people crazy, in a sense? I mean, I just find this hard to accept and understand that at this juncture with fragile communities, of all the 11 considerations, only the one that affects minority communities is the one that jumps off the page at people, and looking at whether or not something designated as systemically risky. I just find that this is anyway, let's just vote on it. I don't want to get...
Well, it's either, Mr. Chairman, it's either systemically risky or it's
Well,
not.
there are a lot of considerations
and
here.
this is obviously politics. It's not policy. But let's vote. Y'all have the votes. We know that.
Well, you can vote. You can vote. You can help us vote
Let's vote.
against your own amendment.
Vote against
Clerk
your...
will call the roll.
Chairman Dodd,
No.
Mr. Johnson,
No.
Mr. Reed,
No.
Mr. Schumer,
No by proxy.
Ms. Lincoln, Mr. Leahy,
No by proxy.
Mr. Harkin,
No by proxy.
Mr. Shelby,
Aye.
Mr. Crapo,
Aye.
Mr. Corker,
Aye.
Mr. Gregg,
Aye by proxy.
Mr. Chambliss.
Aye by proxy.
Clerk will report.
The vote is 5 yes to 7 noes. The measure does not pass.
I thank the clerk. Are there additional amendments to Title I? Nope. Well, at the request of our colleague from Arkansas, the chairman of the Agricultural Committee, I'm not going to ask our colleagues to vote on Title I as amended this evening, because we're going to work on the issue. The Crapo amendment was a close call on this one. I've talked with Senator Collins and explained the vote to her. And so my hope is that, in addition to other matters, we're going to be working on Title VIII over the weekend to work on this until the first part of the week to see if we can't reach some additional accommodation on this matter. So I'm going to delay asking my colleagues to vote to send back to the House our counteroffer on Title I. Are there amendments to Title II in our counteroffer? Any amendments on that? Well, on that one, I'll ask then for all those in favor of Title I as crafted, will say, Title II, excuse me, as crafted, say aye.
Aye.
Those opposed, nay. The ayes appear to have it. The ayes have it. And we will then submit to the House our counteroffer on Title II. And I'm very grateful to my colleagues. We started on such a good note earlier. We ended a little on a sour note there. And I
This has been a great process, and I think we just, we see it for what it is and express that. But look, it's been a great process, and I've appreciated. I think this is going to be a great legacy for you to leave behind, and I hope it continues over the next 10
Better yet, be important for the American people. Let me just say, I didn't understand. In fact, a lot of times I listen to Barney's Heart, even this close, to understand everything. But I want to submit to all of my colleagues the actual titles we'll be involved in on Tuesday that he enumerated. I think he talked about consumer protection and the interchange fees. There are a number of others. We'll get that list for you and send out a notification of what it is. I'm going to urge staff of our respective members here to be available this weekend. We've got a lot of work to do on several areas that we've delayed and deferred that I'd like to see if we couldn't come to some conclusion. We'll be working, obviously, with our House counterparts as well to try and at least come to some conclusion on these outstanding matters so that we can pick up on Tuesday with the remaining titles of the bill and work our way through them next week as well. But I want to express my gratitude to all of my colleagues here as well, to the time you've spent over the last week on these matters. I want to thank our House hosts who have invited us to come to the House Financial Services Committee, and we appreciate very much your consideration and hospitality for us and the remarkable entertainment you provided for us here over the last 3 days. And with that, in the absence of something else, the committee will stand adjourned until further call of the chair.